ladies, thank you so much for joining us today. It sounds like I'm in a boardroom. I am. What I'm going to talk to you today about is intellectual property. I'm not sure if everyone in the room actually understands what all the facets of IP is, so hopefully we're going to go through that. Before I do, I just want to give kudos to Sheldon. He's been my financial planner for at least 10 or 15 years now. He's been a family friend for almost 30 years, and he's the financial planner for both my parents, and we're trying to get him on with my brother. My husband is there, my daughter, everything. We do everything with Sheldon. So I can't speak highly enough for what he's done for my family. And recently I started doing all my corporate investments through Sheldon as well, which is going to be my retirement plan. And yes, we have our wills, which includes a corporate will as well. So if you own a business, if you're going to get your wills done, make sure you get your corporate will done as well. So
good point, yes.
Yes. Okay, so I'm going to do kind of like an IP 101 today. So let's get started. So intellectual property law. Normally when I say intellectual property, women in particular do that. It's like some kind of taboo subject. I quite frequently get comments that IP, it's too hard to understand. I'm not smart enough for that. It's too expensive. I don't have any IP. I'm not big enough to worry about that. These are all common concerns that every entrepreneur comes up with. The reality is that there is intellectual property in every single business. It's whether you can identify it or not. And then once you identify it, whether you have the tools to protect it. And there are certain ways that you can protect it that don't cost any money. So that's what we're going to go through right now. I'm going to give you 3 tips here: how to identify your primary IP, to obtain tips for protecting your IP, how to do it free, and then understanding the risks of not protecting your IP. So those are the 3 things I'm hoping that we can talk about today. There are at least 6 different types of IP. Can anybody identify what those are? You know one of them for sure. Lisa, come on.
Industrial design.
Right, industrial designs. Diana?
I don't know, trademark?
Trademark is one, yes. Doreen?
I guess patent.
Patent is another one, yes. Sandy? Copyright.
Proprietary, I don't know.
So the other 2 are kind of vague, and they generally don't include any type of registration protection, but there's trade secrets, and there's look and feel. So first and foremost, people often confuse the difference between copyright and trademark. So a trademark is your identity. It's the brand. It's the logo. It's the word. It's the mark. It's anything that designates you as the source for specific goods and services. Copyright is any work of art, whether it's literary, a dance performance, a picture, or whatnot. It's the content of that work of art. So when you protect registration for trademark, you're getting registration for a specific word, logo, mark, whatever, in association with specific goods and services, and you are entitled to the exclusive use and profit of that trademark in association with those specific goods and services all across Canada. Copyright registration protects the content. It does not protect the title. So you're protected by from other people to the exclusive use and profit of the copyrighted material, such that other people cannot copy anything and make a profit of it. And there's specific tests for that. I mean, generally we look at a side-by-side comparison, and if there is less than 30% of overlap in there, they may not be able to achieve copyright success on that. But you don't need to register your copyright. You have automatic copyright as soon as you create something. So we'll go into that afterwards. On the other side, as Lisa found out, we confuse the difference between patents and industrial designs. So a patent is an invention that's new and unique and has purpose and utility, like medicine. when you create a medicine that's going to solve a problem, you can get a patent on that. What else? There's computer software. If it performs a specific function that's new and unique, you can get a patent on that software. Sometimes it's not yet here in Canada, unfortunately. Business methods can be patented. So if you have a specific way of providing services that follows the same formulaic outcome, and it creates a very unique outcome, then you may potentially be able to get a patent on that. So on the other side of that, industrial design applications, or what they call in the States called design patents, that's basically a patent for the unique shaping of specific goods. We did one just on Monday, I guess it was, an IP Somm episode where we talked about how the shape of the bowl of a wine glass can affect the flavor of the wine. So, but a glass is a glass is a glass. It's not necessarily a patent anymore, but it becomes a unique shape of it that once it's beyond the 20 years of a patent that it originally held perhaps, then it's the unique shape that can be protected through industrial design. So in Canada, trademarks can be protected now for 10 years. We just changed it, that you get registration, and they can be renewed indefinitely every 10 years. Copyright lasts for 50 years beyond the age or beyond the death of the author as of December 31st in the year of death, although there is legislation right now to increase that to 70 years. For industrial design applications or registration, they're valid for 10 years, and for patents, they're valid for 20 years from the date of filing the application. So those are the general types of IP that we protect. There's other, so when we're talking about trade secrets, so an example of a trade secret would be the Coca-Cola recipe. It's never been patented because people can reverse engineer it, but they also never provided the recipe of it. Nobody still knows it, and that's why Pepsi came around. So what they did was they tried to reverse engineer the actual Coke recipe, but they still taste markedly different, right? So it's held as a trade secret by Coca-Cola. So that just means that they hold the recipe, and they don't allow hardly anyone in the company has access to that actual recipe, and they will never let that go. They never put it out in the public sphere. Look and feel, or trade dress, talks about basically the color, the way your franchise is potentially set up. So if you look at every McDonald's, it looks and feels the same no matter where in the world you go in. So that's a trade dress that they've created, and they can protect that through IP as well. Does anybody have any questions about that to begin with? Sandy?
One, you talked about the copyright having the longest life, if you will, 50 years, but how do people know when it started if you don't have to register?
So when you're talking about infringement, you cannot gain any type of reimbursement for your damages unless you've registered it. So
Even though you don't have to use it.
you have automatic copyright, but if you want to, if someone is copying something and you want to prevent them from doing that, then you can get copyright registration within a couple of weeks. And then you have to sue them in the federal court. So in terms of, so you can have an unpublished copyright, so it has to be out in the public domain, or you can have a published date regardless. So from the time that if you can prove that you've used your copyright or that you developed this copyright and that someone else has copied you, and unfortunately, it can't just be, well, they have very similar types of things. If they've never been exposed to your copyrighted material, it's very hard to prove that they copied it, right? So that's why, generally speaking, once the copyright registration goes in, if there's copyright infringement afterwards, then there's a possibility that they could have seen your copyright in advance. From the time that it goes out into the public domain, that's considered the date of publication. And so if you've ever copied the materials and put them out in the public, so you know when you see on books and they've got the copyright date, so that's the date that it was published by the publisher. If you don't have it published, The easiest way of maintaining your copyright and maintaining proof of that is to make sure that when you create it, you date stamp it, make a copy of it, put it in an envelope, mail it to yourself, and then it's date stamped on the envelope as being your effective copyright date. For electronic things, there are some electronic depositories that you can put your materials into. You pay a fee for it, but they maintain it under the strictest confidence to make sure that nobody else gets it out, so that you can prove your copyright date electronically. If you don't use an electronic storage unit, it's very hard to prove that you created it on that date unless you've encrypted it, so that it can change as of that date. So, any other questions on the actual types of IPs? So the tips for protecting them, there's various tips. I think the easiest one to start with is trademarks. The easiest way to protect your trademarks is to use from the date you start using it, use a TM beside it, so that you've all seen the little subscript TM beside the trademark. Normally it's positioned in the upper right hand corner next to the trademark. Again, does everybody know what constitutes a trademark?
Tell us.
So
Yeah.
I'm going to hand these out in a minute. The Pillar IP, this is my logo. It's Pillar IP, Own Your Idea. That entire logo is protected through trademark registration. So it can be a word, it can be a slogan, it can be a design, it can be a combination of all three. It can be a 3D image, it can be shaping of a wares of goods. It can be a sound, it can be a smell, it can be, it can be pretty much a hologram now. There's all sorts of things that we do with it. So the easiest and the quickest way of at least providing public notice that you're using a trademark is to put the TM beside it. And what that does is when you put the TM beside it, it gives the public an awareness that you're using it as a trademark, and that you perhaps know a little bit about intellectual property and are willing to defend your rights in the trademark. Make sure that you don't modify your trademark every 2 weeks or whatever. Pick a brand and stick with it. Make sure you're responsible for the shape, size, that it's all consistent. Don't allow, if you've got a website, the best thing you can do is encrypt your website so that people can't grab your logos and stuff off your website, to be able to copy them, to use them in however they wish. Use your trademark. Use your trademark with respect to specific goods and services, and make sure that you're defining your services on your website or in your product brochures or whatnot exactly as you would if they were being registered before the Trademarks Office. Of course, the easiest way of protecting your brand is to make sure that you register your trademark before the Trademark Tribunal. The registration in Canada right now, you're no longer required to use your trademark before you get registration, which is a good thing for small businesses. So you can pick a brand. It takes about 18 to 24 months to get registration, but you don't have to use it within that period of time. You do have to use it to maintain your registration, mind you. So, yep.
Good question.
Yeah.
What is the guideline, I guess, when you use a graphic designer to create your logo and your brand? I hadn't heard, and this is why I'm unsure at this point, that sometimes some artists will want to retain somehow.
So normally what happens when you hire someone to create a logo for you, you are commissioning them to perform work for you, which means you own the work. Now, because they've created if it's a logo, a design or whatever, they can assign the copyright in that design for you to use however much you want, but they always retain the moral rights in that design. And that just means...
Yeah, what does that mean?
That just means that if you were to put your logo on something that they were morally offended with, like if you were, I'm not sure what so the woman who created my logo, and once you pay the fee, you own that.
bought it.
Yeah.
You've bought it. I
That's-
mean, that should be in the contract as well, that you have the right to use it however you want. Kind of thing.
Okay.
But if you're providing the designation that they created this, and you put it on a naked statue or something, they may be morally I wouldn't, but it'd be more. It's the Athena pillar. Of course, I'm not offended by that.
Beautiful.
Yeah, so it's like licensing the use of it for something nefarious kind of thing.
So they could say, I designed that, so I guess they can still claim I designed this logo for Diana.
Yeah.
But if Diana uses her logo that I designed for something,
Across my bare chest.
I don't know, it's a tattoo. I think it's offensive.
Yeah.
Really?
Well, I mean,
Okay, that's an extreme, but
that's
it's like, okay.
completely an extreme. I mean, if when I hired my design company to create this logo for me, and I paid them that fee, they assigned all rights, title, and interest to me. So they didn't retain anything. I mean, obviously they're going to know what I'm going to use it on.
Yeah.
So manipulate it to go on something else. But I own that trademark now.
So, for instance, like Shift,
Mm-hmm.
I had that design, so should I have a TM? Is that what you're saying?
You can, but Shift is such
But the way the color and everything is?
yeah. I mean, you can certainly put a TM on there.
Okay.
But the registration would only, I mean, the rights that are extended to you from that is only as good as how limited the other use is out there, or inherently distinctive the trademark is in the industry that you're working within. So Shift, the words may not be protected because a lot of people use that terminology for consulting, marketing, those type of events kind of thing. However, the color and the actual look and feel of
Font.
that
Right.
font could potentially be protected, yes. I mean, there's certainly copyright in that from right off the bat. There may not be trademark protection, but there's certainly copyright in the design that you would own.
Just as an example, I think, so when I had the Storm logo design,
Mhm.
the person designed it, I retained all rights.
Mhm.
Years later, she is an artist and she created a painting that it was like the next phase. And so I approached her if I could use it. And so what she's done is she's given me permission
Right.
to use it on my website. And every few years, we just get in contact with each other for me to say, do I still have permission?
Oh, that's great, yeah.
So is that?
Yeah, I mean, that's her retaining moral rights and having the ability to assign you to use that. And when you're assigning rights, it doesn't necessarily mean that you're paying for it. Sometimes you can get royalty-free rights as well. It's you're licensing the use of a trademark or copyright that inures to the benefit of the retained owner. Does that make sense?
And there should be a paper trail of that, so I should keep the emails that says that we have
Yes,
this
in
agreement.
case there's
In
any
case
problems.
there's a problem.
It's the CYA approach.
Right.
Yeah, so trademarks and copyright, we're okay with that. So copyright, you can always use the C in the circle on everything. I encourage each and every one of you, if you have a website, to make sure that you've got copyright notice on each and every page of your website, because that protects the look and feel of your website. Put the date on it. You can say from the date it was created until the present day, so that people understand that they can't adopt and use the look and feel of your website for their own website kind of thing. If it's a cookie cutter website, you've used a template or WordPress. Well, but even WordPress, I mean, my website is a WordPress, but the design of it is completely different. Because I've got the pop-up windows that come up, and then the shapes and the colors and everything, I mean, those are protected. But if you're using like a Wix site where it's just plugins, you may not have the right to the entire thing. That doesn't stop you from using copyright because it protects the content that's within the website as well. They're using the copyright notice. Make sense? So those are really easy fixes that you can do. I would encourage everyone to police their brands. If you've got a unique, like Eye of the Storm, every once in a while, maybe once every 1, 2, 3 months or whatever, just do a quick Google search on Canada and on .ca and .com to determine whether anybody else out there is using it or if there are any other hits with yours. Put your trademark in quotes so that you're only getting that Boolean search to determine if somebody else is using your trademark. And if someone else is using your trademark, then I would encourage you to contact me. I mean, there may not be any infringement whatsoever, because it depends on whether they're using it in overlapping goods or services. But it's better to get a second opinion or a first opinion than to just let it go and say, oh, it's not, or to combat them and say you can't use this anymore, only to find out that they're not a problem.
So I have a question on, let's say it's a methodology.
Sure.
So I work with a lot of clients and they develop their own methodology. XYZ method.
Yeah.
So should they be putting TM?
So when you're talking about methodology, are you talking about like their business plan?
No, I'm talking about, for instance, let's say they have, 5 steps to relief from chronic pain, and it's their specific method. Nobody else does it like them.
Right. So this is a tough one because I think Janelle and I were talking about this in the car on the way here. There's trade dress, there's trade secret, and then there's influencer stuff. So if you're trying to gain notoriety based on your products or services, then and you're putting that methodology out into the public eye, absolutely put a trademark on it. Call it something that's very unique.
Yeah.
You can put a trademark on it. But the reality is people, if it's going to work, they're going to adopt it. But if you can become the one who's got the most notoriety on that, you become an influencer in there, you become the person who has the first step into that, then that may be the protection that they need. You don't put a trademark on, see, it would be potentially copyright protected for the content of it.
Right.
But then name the methodology something completely unique and
Right. So for instance, this person, let's say she used her first name.
that's not unique.
No, but her first name method.
Yeah. Sure. I mean, it's not a great trademark,
No, well,
but
it's
Yeah.
it's to hers.
choosing a trademark that is protected, that you can have the exclusive right and use to. There are certain things that you cannot have as a registrable trademark. So you can certainly, everyone's entitled to use their name, but you can't prevent other people from using the same name if that's their name on the exact same
Right.
services. So
Okay.
that's why it's not necessarily
No,
a protectable trademark.
yeah.
So, Sandra's methodology, any person named Sandra can adopt and use the exact same thing. They can, your client can protect themselves through copyright protection. So they can't, nobody else can use that exact same wording and those steps in that order kind of thing if they register the copyright for that. If they were to call it the sandstone methodology, and like sandstone is not a last name, if that's the case, then that would be a more unique thing. And then you've got notoriety, you've got influence power by putting it out into the public domain. So you copy it, you've got copyright protection, and you can get trademark protection from that. Does that make sense?
Yep.
So the things that can't be a trademark, you can't be the name or surname of an individual who's living or deceased within the last 30 years. It cannot be the clearly descriptive or what we call deceptively misdescriptive of the goods or services or the character of the goods and services with which it's being provided. It cannot be the name in any language of the goods or services. If you've got a chair and you call it chaise,
Right.
you can't do that. So
Can't
it's any
trademark
language.
it, that.
Any language. It can't be just, when I was talking about the other one, descriptive or deceptively misdescriptive in French or English. So that's the caveat there. And it can't be confusing with an already registered or a previously used trademark in Canada. So those are the main criteria that we look for when you're trying to choose a trademark. So I really encourage people when they're naming their businesses to get the help of a consultant who knows what's a registrable mark or not, and a marketing company who has some kind of creative element to them so that they can come up with a brand or identity that you will use, because it really does become your company reputation. It's your company identity. It's where you will make your most money. People will identify with your trademark before they will identify with whatever goods or services you're providing or how good you are or not. So how to identify your most prominent IP is, first of all, what's your reputation, where are you making money? Once you identify where you're making money, where your money is coming from, that will be your primary IP. Whether it's from a business method or a financial schedule that you've created, whether it's from your name and your reputation, whether it's from a program that you've put together for helping people connect, whether it's from writing about doing all your research or whatnot, there is IP in every single thing that you do. It's about identifying where you're making your money. When we work in IP, the most relevant factor when it comes to assessing whether there's confusion is to follow the money. Every single time, follow the money, because that tells you who's using it more and who's using it, how they're using it. And I'm always here if you have any questions about what your most prominent IP is. Protecting your most prominent IP is really valuable. However, if you have no intention of ever going beyond the auto market and you're using it particularly with trademarks and copyright, there's no need to register. With copyright, unless you know that someone is going to come along and copy it, send out more than 25 copies and try to make a profit from your materials, you don't need to register it. Although copyright registration is really inexpensive, I think it's a grand total of $350, which includes the government fees, and it gives you protection for 50 to 70 years, and you get the registration certificate within a month or two, maximum. Trademark registration is a little bit more expensive, but it's your most important asset because it is your identity, it is your reputation, it is how people recognize who you are and what you do. If you're not going beyond the auto market, you have common law rights here in Ontario that protect you for the geographic location in which you're doing business. If your business is strictly online, you must register your trademark so that you're covered across Canada. And if you're making more than $2,000 a year, then register your trademark, because that's about all it costs to register it, and it will allow you to use it exclusively and profit from it across Canada, and prevent other people from adopting and using your brand, your look, your feel, that kind of thing.
$2,000 a year?
Yeah, I mean, it's total about $2,000 over the course of 18 months to 24 months to get registration, and then you renew every 10 years.
Oh.
So, yeah.
When I come across certain women entrepreneurs, for instance, we're talking about exit strategies, bringing on, a partner
Yep.
or selling your business. I sold my business 3 years ago to an employee, and do you have any insights on what registering of trademarks can do to the value of the business that you've built?
Certainly.
Certainly.
A trademark is a corporate asset. It's tax deductible. All the legal fees that go into your trademark are tax deductible. It can be a chattel for you to obtain loans. If you assign it, you can get monetary value for it. If you have a partner come in, you can require that they contribute to the cost of that trademark. If they want ownership or pay you for ownership of that, or you retain it yourself so that they never own it, and then when you sell the business, you sell it with the trademark and everything. Remember, when you're selling a trademark, you're selling not only the assets of if you're selling your business, you're selling not only the assets of the company, but the reputation that goes with it. That's valuable for everyone. I mean, if you're a McDonald's franchise, that's why you pay so much for a franchise, because you're buying the right to use a really famous trademark and identify with them. Unless you're manufacturing specific goods, you probably won't come across industrial design applications or patents, generally scientific research, those kind of things all deal with, or creating new machinery, that kind of things. They deal with patents, industrial design. So if you have an idea that you think, oh, this is the next big thing, remember, you don't actually have to create that invention. You just have to figure out how it works and how to write it down to get a patent, and then you can sell that idea and make a ton of money off of that if it's worth. Yeah.
So I have a quick question, because I know one of our business, our women entrepreneurs coming to the event, recently bought a patent that was expired.
Why? Once a patent expires, it's in public domain, so everything that's in there, she's entitled to use.
Okay, well, I may have misunderstood.
Yeah.
It's a very innovative product that was never really marketed, and,
So she wouldn't have had to buy the patent.
Okay.
though, but-
all right, I may have misunderstood, and
Okay.
if, when she confirms, I'll put the two of you in touch there.
Yeah,
Because it's
I'd
pretty
be really
interesting.
interested to find out.
Yeah.
Because I mean, the whole reason behind patents was to create a learning environment for people. So people would create an invention, have an invention, and they would write out a patent spec, which actually teaches you how to create and recreate this invention and the steps that you have to go through to do that. So that's why they're entitled to 20 years of exclusive use and profit, because of all the amount of research and design that's gone into creating this patent, and then potentially the money spent on prototyping and then marketing it and selling it and those kind of things. That's why patents are very expensive. But once the patent expires, all that information goes out into the public domain so that everyone's entitled to use it. Yeah.
And so this new person cannot actually protect it anymore.
No,
Interesting.
yeah.
I may have
If
misunderstood
it's
what
an
happened
expired
with her
patent.
business.
Yeah.
But I thought, yeah, okay. I will check it out.
So just one final thing to end, if you do not protect your IP, the risks that you face could mean taking away your entire business, because you're either infringing someone else's rights, or they can basically steal all your rights if you don't protect your rights and you don't have the fortitude to go after them. So you can't sell what you don't own.
And so what happens if your business explodes and you're now working within the US and other countries?
So each country has its own patent or trademarks office. So that's why I'm registered to practice before the USPTO for Canadian applicants for trademarks. And I've got patent agents in our firm that are licensed to practice in the US for patent files there. We have a network of associates worldwide that practice in all of the various international patent and trademark offices as well. So that's why we do portfolio management as well. So we can make sure that we're doing consistent registration or protection throughout the world, wherever you're doing business. Yeah, thank you.
So how much approximately would it be to license in the US then?
To license or to get registration?
Or to get registered?
It's about $2,000
For each
US
country.
dollars.
Yeah.
Yeah, for that. Over in Europe, you can get a European trademark. I'm talking trademarks here because it's the easiest. It's European Union right now, which still includes the UK until we don't know when. It's about almost 4,000 Canadian to get registration over there, but it covers 27 member states.
Yeah.
In Japan, it's almost $5,000 just for a trademark. It's, yeah, so various countries can be really expensive, but the financial, in Japan, when you get registration, it's ironclad, nobody else can go in there, so.
Well, that's awesome, Heather.
Yeah.
Thank you very much.